Today we're going to discuss the financing contingency addendum in detail.
So stay tuned.
Hi there, thanks for checking us out. It is Beth
And Shirley
with Shirley's Real Estate Group, John L. Scott, and this is the BS Real Estate Show.
Beth and Shirley, that is. And we're here with more real estate news that matters to you.
Today we figured we'd go over Form 22A, the financing contingency addendum in detail regarding timelines, obligations that the buyer must comply with in order to ensure their earnest money is protected and they don't waive their financing contingency without knowing, and the different forms that are used throughout the financing process. There's a lot to take in, so get ready.
To start off, the 22A Financing Contingency Addendum is a form that's entered into the contract by the buyer if they're planning on financing any of the purchase. This is a request of the buyer to the seller to allow them the opportunity to complete the loan process, which in turn is asking the seller to carry the burden of removing the home from the market while the buyer works towards obtaining that financing approval. In regard to the seller carrying the burden, this will make more sense as we get into the other forms that are used in conjunction with this form.
The first part of the form discusses the loan application. The buyer will select which financing product they are planning on proceeding with, whether it be conventional, FHA, VA, USDA, etc. Keep in mind this will also be noted on your pre-approval letter that is submitted with the offer. It'll also state the percentage that the buyer intends to pay towards the down payment. The buyer must make loan application with the lender within 5 days of mutual acceptance of the contract. In the event the buyer chooses to proceed with a different lender other than the one that initially issued the pre-approval letter, the buyer may do so without the seller's approval as long as it's within the initial 5-day period.
At any time, usually 10 days after mutual acceptance, but that can be negotiated too, the seller can request information regarding the buyer's status of their loan application by utilizing the 22AL. Within 3 days of the buyer receiving the loan information request, again the 22AL, the buyer shall provide the seller with the 22AP. This form will list the information that the buyer has provided to the lender, the date the buyer made loan application, the name of the lender, a list of the items that they provided to the lender, and a warranty that they have provided all items that the lender has requested. The seller has agreed to accept the 22A as part of the contract with the expectation that the buyer will operate in good faith to obtain that financing approval in a timely manner. If the buyer fails to provide the seller with the 22AP within a timely manner, the seller then has the option to, at any point moving forward, issue a 22AR, which is a notice to waive the financing contingency, or the seller can terminate the contract.
If you're still with us, we've got more for you.
So given we just brought up the 22AR, let's move into that form.
Okay. If the buyer didn't respond timely to the 22AL, then the 22AR time frame in the contract doesn't apply. But if they did, then the time frame outlined does. It's usually 30 days after mutual acceptance, but again, this can be negotiated. The seller can deliver a 22AR to the buyer. If the buyer has not previously waived their financing contingency, this form is the seller asking the buyer to be confident enough in their loan process and their ability to close and waive their financing contingency, or risk the seller terminating the contract.
So keep in mind, as we mentioned before, when the buyer added the 22A into the contract, when submitting their offer, they were asking the seller to carry that burden for them to obtain financing.
In the event that 30 days has passed and the buyer doesn't have final loan approval, things aren't progressing as they should, if the buyer isn't willing to waive that contingency, or they don't have confidence that the home is going to close, then there may be reason for the seller to choose to terminate and proceed with another buyer before they lose additional days on the market.
So let's jump into the notice of low appraisal, the 22AN. In the event that the lender's appraisal comes in lower than the sales price, The buyer, once they receive a copy of that appraisal, will have 3 days to provide the seller with the 22AN and a copy of the appraisal report. Once received, the seller will have 10 days to respond back to the buyer, and they'll have 4 options. So one, they can have a reappraisal completed, which would be at the seller's expense, and in the event that it does come in at value, they can submit that then to the buyer, and they'll send it to the lender seeking approval of that appraisal.
2, they can consent to reduce the purchase price to the appraised value. Or 3, they can propose to reduce the purchase price to amount higher than the appraised value. In that case, the buyer would need to bring in additional funds to the closing table to cover the difference.
So, or 4, they can flat out reject the low appraisal, in which the buyer would need to bring additional funds to the closing table, and that would be the full difference between the appraised value and the purchase price. Or the buyer can choose to terminate the contract. In the event that the seller issues their response or fails to respond, the buyer shall have 3 days, beginning from the receipt of the seller's notice or at the end of the seller's 10-day period, to waive their financing contingency, agreeing to move forward with whatever options were agreed upon, or terminate the agreement.
Now let's get into the tricky part of this form that often costs the buyer their earnest money and they aren't even aware of it. You automatically waive your financing contingency if you do any of the following. If you fail to make loan application for financing with the agreed upon time frame, you change the loan type at any time without seller's prior written consent. An example is mentioned if you decide to change lenders day 5 after mutual, great. Come day 6 without prior permission and you just waived your financing contingency. Same goes for loan application. If you don't make a loan application until day 6, your financing contingency is waived.
So what exactly does this mean?
Okay, well, if you no longer have a financing contingency and your loan request is denied or your appraisal comes in low and you aren't able to reach an agreement, your earnest money, which is typically around 1% of the purchase price, which
Not a small chunk of change.
no, it's not, is now at risk, and the seller will likely take it as damages given you didn't abide by the agreed upon contract.
Exactly. So while you're being represented by a licensed real estate broker, and they should know the contract to protect you and your earnest money, it's also important to make sure you're working with a competent lender. Without knowing it, if they don't abide by the guidelines set forth in the 22A, they could put your earnest money at risk too. The buyer's agent and lender should always work closely together throughout the entire process to ensure nothing is missed.
Hopefully that wasn't too overwhelming and you were able to take in the importance of how complex this form is and how important it is to work with a well-educated and experienced real estate professional.
So make sure you stay tuned for our upcoming videos.
If you have any questions that we didn't cover, reply below, call, text, or email us. If there's a topic you'd like to hear about or an idea you have for a future video, please let us know. If you like the content that we're putting out, don't forget to smash the subscribe button, turn on the bell icon notification so you get our future videos. Well,
that's a wrap. What a bunch of BS. See you next Tuesday.